Have you ever wondered just how far you can legally go to defend someone who's being attacked by a ghost? Me neither. But in case you are out walking one night and pass by a dark, secluded alley, then witness a ghost attacking some innocent person, a legal case that happened over 200 years ago gives you some guidance in this. In 1803, in the Hammersmith borough of London, a ghost appeared and began to harass the people of that small town. Locals said that the ghost was of a man who had died by suicide the previous year and had been buried in the churchyard. Their belief was that suicide victims should not be buried in consecrated ground, as their souls would never be at rest. The ghost was described as being very tall, with horns, large glass eyes, and wearing a white calfskin garment. And stories about this ghost soon began to circulate all over town. Two women, one elderly and the other pregnant, were reported to have been seized by the ghost on separate occasions while walking near the churchyard. They were apparently so frightened that they both died from shock a few days later. A servant testified that while walking through the churchyard with a companion one night, something rose from behind a tombstone and seized him by the throat. Hearing the scuffle, his companion turned around, at which he said that the ghost gave him a twist round, although he saw nothing. He then said that he gave a bit of a push out with his fist and felt something soft, like a great coat. One night, a watchman saw the ghost and gave chase, but the apparition threw off its shroud and managed to escape. London didn't have a police force at the time, so citizens banded together and began to patrol for the ghost. While making his rounds at night in 1804, a watchman met with one of the armed citizens patrolling the area, a 29-year-old excise officer named Smith. Smith had a shotgun and told the watchman that he was going to look for the ghost. The watchman agreed to join Smith at 11 p.m. and that they would take the ghost if possible. They then went their separate ways. While patrolling, Smith encountered a bricklayer who was wearing the normal clothing of his trade, which were white linen trousers, a waistcoat of flannel, and a white apron. The bricklayer was heading home from a visit to his parents and sister. According to the bricklayer's sister, immediately after seeing her brother off, she heard Smith challenge him, saying, "Damn you, who are you, and what are you? Damn you, I'll shoot you." Then Smith shot and killed him. After hearing the shot, two neighbors met Smith, who say that he appeared very much agitated. Upon seeing the bricklayer's body, they advised him to return home. Later, a constable took Smith into custody. The bricklayer's corpse was carried to a coroner who pronounced the death to be the result of a gunshot wound on the left side of the lower jaw, one of which had penetrated the vertebrae of the neck and injured the spinal marrow. Smith was put on trial for willful murder. The bricklayer's widow stated that she had warned her husband to cover his white clothing with a coat, as he had already been mistaken for the ghost on a previous occasion. She stated that one night her husband said he had frightened two ladies and a gentleman who were coming along the terrace in a carriage. That gentleman had yelled, "There goes the ghost," and almost got in a fight with a man. And the widow begged her husband to change his dress so he wouldn't run into any more danger. The bricklayer's sister testified that although Smith had called on her brother to stop or he would shoot, Smith fired the gun almost immediately. Despite a number of declarations of Smith's good character, the Chief Justice advised the jury that malice was not required of murder, merely an intent to kill. The judge observed that Smith had neither acted in self-defense nor shot the bricklayer by accident. He had not been provoked by the supposed apparition, nor had he attempted to apprehend it. And even if the supposed ghost had been shot, it would not have been acceptable, as frightening people while pretending to be a ghost was not a serious felony, but a misdemeanor. After considering for an hour, the jury returned a verdict of manslaughter, but the judge informed the jury that the court could not receive such a verdict and that they must either find Smith guilty of murder or acquit him. The jury then returned with a verdict of guilty. After passing the customary sentence of death, the judge said that he intended to report the case to the king, who had the power to commute the sentence. The initial sentence of hanging, drawing, and quartering was commuted to a year's hard labor. But what about the ghost that caused all of this chaos? Well, the publicity persuaded the true ghost to come forward. John Graham, an elderly shoemaker, had been pretending to be a ghost while using a white sheet to frighten his apprentice, who had been scaring Graham's children with ghost stories. There was no record of Graham ever being punished. A question of whether acting on a mistaken belief was a sufficient defense to a criminal charge was debated for more than a century until it was clarified at the Court of Appeals in 1984. Gladstone Williams had seen a man dragging a younger man along the street while he shouted for help. Mistakenly believing that an assault was taking place, Williams intervened and injured the apparent assailant, who was actually attempting to apprehend a suspected thief. Williams was subsequently convicted of assault. At the appeal, Chief Justice Lane referred to the case that I just talked about with the ghost. He said that if the jury came to the conclusion that the defendant believed, or may have believed, that he was being attacked or that a crime was being committed and that force was necessary to protect himself or to prevent the crime, then the prosecution has not proved their case. If, however, the defendant's belief was mistaken and an unreasonable one, that his defense should be rejected. And the 1984 appeal was allowed, and Williams' conviction was quashed. That decision was later written into law in 2008. I have thought a bit about what I would do in a situation like with that ghost assaulting someone. Over the last decade or so, with ring cameras, phone cameras, cameras in cars and mounted on buildings and streets, if someone is really being victimized and you don't try and help, you may end up with an internet full of people calling you a coward. But if you do help, you can be the one who gets victimized or even sued and charged with a crime. So I guess I would call 911 and try to record the situation and maybe yell that the police are coming in hopes that that criminal would run off and not come after me. And if I was walking home one dark night and I passed a dark alley where a ghost was assaulting a person, and I mean a real ghost. It was floating and you could see through it while it was making these horrifying shrieking sounds. I would probably at first go, holy cow, that's an actual ghost. Then I would just go home. Because if you did something so bad that you pissed off a ghost, you are on your own. Good night.
Boo.